Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Everyone, please be seated. We are here today for the submission of 4 different cases. The case of Iowa Supreme Court Attorney Disciplinary Board versus Scott Sobel is hereby submitted without oral argument. We will begin our first oral argument at this time, and it looks like counsel is ready. Mr. Leach, it's my understanding you'll be arguing? Okay, you may proceed.
May it please the court, Madam Chief Justice and Mr. Schmitt. This appeal involves a Federal Employers Liability Act cause of action. It was brought for severe injuries that our client, Mr. Olsen, suffered due to railroad negligence. The jury returned a $6.2 million verdict, which the trial court affirmed. There is no allegation in this appeal that the verdict is against the weight of the evidence or that the evidence was insufficient to sustain the verdict. And those are important points because that means the judicial system did what it's designed to do, which is to produce results that are consistent with the weight of the evidence. This appeal is about a verdict form that was not objected to. It's about whether a footnote in this court's Whitlow opinion has abrogated Rule 1.924 and whether it has now authorized the practice of sandbagging in Iowa trial courts. And unless this court tells us otherwise, it seems reasonable to read Whitlow not to trump Rule 1.924 and not to authorize sandbagging. The most reasonable reading of Whitlow is that Whitlow is a creature and bound to the procedural facts of Whitlow. It's limited to Whitlow's exceptionally unique procedural facts of that particular case. Even if the court were to tell us that Whitlow actually does mean that Rule 1.924 is to be set aside and that sandbagging now is authorized in Iowa trial courts, even if that were the case, this jury was properly and thoroughly instructed.
This record that sandbagging was what was going on?
We've discussed that. It depends upon what the definition of sandbagging is. I know that when we usually use the term sandbagging, it's a lawyer who says, oh, good, I've got an error in the case, so I'm not going to say anything. Actually, it's a bit broader than that, at least in my understanding of it. Sandbagging also includes when at trial, for whatever reason, you don't object. And there are many reasons why a lawyer may not object. One reason may be they just were busy, as I'm thinking a mile a minute right now, and they're missing things. Or perhaps they said, you know what, that's probably error, but it doesn't really matter. Or what they do is they think, well, you know what, this is not error at all. But once the adverse verdict comes in, then you scour the record to see if there's anything you can argue was error. So long as Rule 1.924 is in effect, none of those possibilities are allowed. The Whitlow footnote, the interesting thing is, you know, we all talk about what dramatic changes this will be if lawyers are allowed to do any of those things I just described. But one of the things that the Whitlow footnote does is if it does authorize sandbagging under any of these terms, then lawyers are obligated after trial to do what they were not allowed to do under 1.924. We are obligated now after trial, whether we objected or not, to go look through that record and see if there's anything we can argue as error and then raise it and then claim that Whitlow allows us to raise it because Whitlow in the elements of the footnote says, well, if it wasn't raised at trial, you can claim it was overlooked. Well, that's an interesting thing because when you claim an error is overlooked at trial, you're talking about something under one situation, nobody thought it was error. So nobody overlooked it. And in fact, this is...
To the verdict form that was actually submitted?
They did. And what
even apply.
Honor, that's exactly right. This case does, this court could, if it wanted to, which I actually hope the court doesn't because we would like to get guidance on Whitlow. But this court could say, this is not a Whitlow case for two reasons. One is, this isn't a case, whereas in Whitlow, the jury didn't return a verdict. Yeah, in Whitlow, you can take a blank piece of paper, the jury was allowed to walk out of the courthouse having turned in a verdict form that had nothing on it. The essence of the judicial process
Exonerated the one defendant and then stopped due to the mistake in the verdict form. And then Whitlow's different from this case in that there was the plaintiff's claim against the other defendant wasn't considered by the jury. Here we have a jury verdict on the claim. Okay.
we have an exceptionally thorough jury verdict that was the result of consensus at trial. I was thinking, Mr. Schmitt and I, we know each other. We're all in the same industry. We all, everyone out here knows each other. And when we are at trial, we are obligated to do things by consensus when we can. It's not this idea that we're adversaries and we need to fight about everything for advantage. We have an obligation as officers of the court to do our best not to be here right now, to produce a verdict that is consistent with the substantial evidence and the weight of the evidence that then you don't have to hear. You can hear other matters. You don't have to address a case like this. Yes.
You said there was an agreement to the verdict form here. My understanding of Whitlow, at least, is maybe there was an implicit agreement, right? I mean, they had an instruction conference. They reviewed the instruction. It was submitted to the jury. So what makes this case different in terms of this agreement issue versus Whitlow?
There was not just an implicit agreement. We worked together on this verdict form. As the court can see at pages 85, 86, and 87 of volume 6 of the transcript, the issue that is alleged as error right now, the idea that, wait a minute, you need on a verdict form to actually have the question that says, first, separate from causation, was the railroad at fault? The idea that you need that was discussed in the instruction conference, and in fact, it was brought up by trial counsel. Mr. Schmitt is appellate counsel. Trial counsel was Mr. Hawes. Mr. Hawes brought that up, and he brought it up in context of the question we were talking about the contributory negligence verdict form under FELA, unlike Iowa comparative fault. This is not a 668 case. Unlike that, we have contributory negligence. The railroad has negligence under the contributory negligence instruction. We were discussing what terms we should use. And Mr. Hawes said, he said, fault is being set out here as the combination of negligence and cause. So we have to use that terminology in order to get to the verdict form, meaning that we have to look at these instructions, which is what the standard of review requires, as a whole. And he was saying that in the elements instructions, that define the elements of negligence on behalf of the railroad and contributory negligence on behalf of the employee, we have to separate those out. We then did, right there and then, the court separated those out and asked, and we all were satisfied with that the jury instructions separated them out. The verdict form then combined them, and we discussed that.
Stop you just for a second. The verdict form that the district court or the trial court provided to you for your instruction conference, obviously I don't think should have been in the record and is not, but is it the same verdict form that was actually submitted?
We're in the record actually. It was a 668 verdict form, and you can read
68. Then the 668 one starts with were they negligent, and then second question. So is that? What did the verdict form look like that because I know the court proposed and its version of instructions and a verdict form.
Yes, if you look at the Iowa pattern jury instructions and look at the one for 668 cases, it was exactly 668. And that was the problem in the case, and another reason why
was provided by the district court to the parties.
The one that was provided by railroad to the court, then the court modified, of course, caption and those things.
Court provided you with here's the instructions that I'm thinking of, and here's the verdict form I'm thinking of. Was that verdict form the one that was ultimately used?
It was not.
like the original 668 form?
Here's what happened, Judge, because
Following up on that, so I'm still struggling with this idea of agreement. So my understanding is that there was this 668 form. There's this incredibly long colloquy on the jury instructions where they're contesting negligence, fault, 668. And it's not clear to me that this verdict form was presented to the lawyers and they said, yes, this is the right form.
the verdict form that was eventually given to the jury is the one that under 1.924 we were given before the jury instruction conference and pursuant to the procedure given time to study it. That is the verdict form that you have. The verdict form that you have is the one that, or I strike that, I just misspoke. That is not correct. That's not correct at all. What the court gave us was the 668 modified for the FILA case. Because this, one of the elements of the Whitlow standard is whether or not the proper verdict form was given, proper instruction. It was not.
68 modified, is it the one that the jury used? So that, okay, so you had a different form after your conference, then the verdict form changed too, as well as the instructions?
So the verdict form changed because we had all these discussions that you see. So she tried to accommodate all of those discussions. And one thing she did was she recognized that under the FELA, this apportionment of fault is only between two people. Under the FELA, you cannot have any parties other than the employer-employee, so it's always just in front of two. So that presents two questions. Was the causal fault, which is combined fault and causation, was that, did that contribute to any damages? Was that a result of any damages? And was the contributory negligence the result of any damages? Those are only two. So we talked about we combine and uncombine, and Mr. Hawes, defense counsel, both in the instruction conference and in front of the jury, talked about these combine and uncombine. So what the court did is drafted an elegant verdict form, which says we have two things to separate, so we have two questions. And then after that, just to make sure that the question of negligence must be decided before damages are awarded, if you look down after the apportionment portion, it specifically says, now don't award.
I want to take back to this issue again. So just bear with me here. I want to clarify the record. There's a very long instruction conference that deals with this issue of negligence, fault, 668. You cited some of it here, 85 to 87 in the transcript. That conference, when they were having that discussion, the verdict form that was proposed is not the verdict form that we are talking about here. Is that
Verdict form we're talking about here, defense counsel, the court, and we created that verdict form.
page in the record where the verdict form that's at issue here, the judge says, here's the new verdict form based on the arguments we've had. This is what we're going to use, and the lawyers explicitly bless that form. Okay, that'd be great.
Blessed that form. It was only explicitly blessed as part of the complete package at page 108 of volume, either 6 or 7, I believe it was volume 7, might have been 6, where the courts came out after we all worked together on this. We all agreed on how it worked. And then the court came out and said, so based on the revisions that were discussed here this morning, referring to exactly the things you just referred to, Your Honor, the court now has instruction numbers 1 through 27, which will be provided to the jurors in this case. I'm going to go ahead and have Diane print a new copy of the jury instructions as they've been revised during the course of our conversation, so you have that and you're able to follow along. Then, just procedurally, the court will read the jury instructions to the jury, et cetera, will release them. I'll state in closing arguments, et cetera, and they'll rescind. After she explained that, she said, and any further record that needs to be made outside the presence of the jury, Mr. Leach, me, no, Your Honor, Mr. Hawes, nothing, Your Honor. Thank you.
It strikes me that Whitlow is quite different from this case in the sense that, as I recall, because I was on Whitlow, there were two parties two defendants, and the jury stopped at one, and the judge ordered a new trial, and the issue on appeal was there who was going to be in the soup for the new trial? And we then put in this footnote and said, well, the error was preserved even though nobody objected to this verdict form at the time. But it seems to me that's a lot different because you're reviewing the judge ordering a new trial, and there almost had to be a new trial because you had a defendant. I mean, there could have been some other grounds for ordering a new trial when you have a defendant that the jury just doesn't get to. I mean, we could have put some other footnote in to finesse that issue.
You did put another footnote in to finesse that issue. You put in footnote 5. Footnote 4 is the one that everyone's all exercised about. You put in footnote 5, and what did you say in footnote 5? Or Judge Waterman wrote the decision. We remind counsel and trial courts to carefully scrutinize verdict forms before submission, and the jury should not be discharged before the court ensures the verdict is complete. In other words, don't do this to us again. Don't do this to us again where, the lawyers, the practices, lawyers often go back to their office, the jury comes out, gives its verdict, it's dismissed, and then apparently the court then looked at it and it was like, oh, doggone it, they didn't even fill this thing out. Too late at that point. So what the court has said is never let there be another Whitlow again, and there should never be another Whitlow again if we do what you say to do, and if we do what the trial court in this case did. The trial court in this case did exactly that. And in fact, after new trial, these issues were not addressed in the jury instruction. These issues were addressed in the jury as stated, but nobody said, okay, now that we've concluded and we've all worked together and we've come with our final product, I object to that final product. Nobody did that. But after trial, the court was presented with it. When it was too late to do anything about it, the jury had already been sent away, and she concluded, we believe correctly, that the instructions as a whole, which is how you should read them and how we tell the jury to read them, so adequately submitted the question of negligence and causation separately. Thank you, Your Honor.
Let's come back. Mr. Schmitt.
May it please the court, counsel. I represent BNSF Railway, and I'm here to talk to you today about this appeal. Specifically, the Court of Appeals correctly reversed the decision of the trial court and remanded the case for a new trial. And the reason that the Court of Appeals correctly remanded this case for a new trial is that the trial court committed an error of law in regards to the jury instructions that were issued in this case. This case was filed under the Federal Employers Liability Act, and under FELA, there's 3 required elements: negligence, causation, damages. And Mr. Leach acknowledged that negligence was a significant issue in the case. And the problem with the trial court is that the trial court omitted from the verdict form the threshold question whether or not BNSF was negligent, whether or not it was at fault. And because of that, the jury was never given an opportunity to make a finding whether or not BNSF was negligent.
Merge the two issues, I mean, negligence and causation, into one interrogatory for both the plaintiff and the defendant. I mean, if the defendant wasn't negligent, then their negligence wouldn't have been a cause. I mean, if I were a juror, I think I could have managed to figure that out when you add the instructions in, right?
Disagree. The trial court attempted to follow the model Iowa civil jury instructions. And in the model instructions, there are 2 separate discrete questions, one for negligence and one for causation. And the reason that there's 2 questions is because there's 2 issues. The verdict form in this case that was given to the trial court is word for word out of the model instructions regarding the question of causation. Word for word. So obviously the authors of the model instructions felt that it was not appropriate to combine these very 2 significant separate discrete issues, or they would have done so.
And Mr. Leach read to us from the transcript where there's, after this post-instruction conference, the judge comes out and says, here's the revised instruction packet. Do you want to make any other record on it? If the lawyer thought that there was an element missing from the verdict form, wouldn't that be the appropriate time for somebody to say, hey, we think this misstates the law? So is he wrong when he read that there was consent to this verdict form?
The reason that there was not an objection to the verdict form that was ultimately given to the jury is it was overlooked by the trial court and by counsel. And so respectfully, what Mr. Leach is trying to argue in regards to what the transcript says or what happened at the trial during the trial itself, I'm going to rely on the transcript and what the transcript says, because that's the record here on appeal.
There was no objection to it.
Objection, agreed, Your Honor.
I mean, we've seen cases like this before where an instruction becomes, whether you like it or not, that's going to stick with the case through appeal and everything. I imagine almost virtually every one of those cases was a, quote, error by an attorney to not notice. So why should we treat this one any differently, an oversight?
An oversight, even the trial court acknowledged that it overlooked the error when it ruled on the motion for new trial. The trial court overlooked the error and the attorneys overlooked the error. Mr. Leach was citing from the transcript, and in fact, he referred to the fact that the court came out of, well, first of all, Mr. Leach acknowledged that the parties were not given this verdict form during this instruction conference when they were discussing it. He then says, well, then the trial court came out and it provided the parties with instructions numbers 1 through 27, and that's in the appellate record. Verdict form is not attached to those instructions 1 through 27.
Conference, when they were discussing the instructions, they had some kind of verdict form, it seems like, and your co-counsel specifically talked about this idea of causal fault, and the concern seemed to be from the defendant's perspective was we don't want to have an issue of yes on negligence and no on causation and then still get a percentage. And so that seemed to be contemplated even by your co-counsel that we need to combine those into one question for the purpose of so that we're sure that when they give us a percentage that there's no room for error there.
Discussion cited by Mr. Leach dealt with the question of causation. It did not deal with the question of negligence. Nowhere in the record did the parties ever agree that the court could eliminate.
Fault is being set out here as the combination of negligence and cause.
Get to question number 2, which dealt with causation. No one agreed in this transcript or on the record or anywhere that the court did not have to instruct the jury on the question of negligence. That's why we're here today. And the reason that we didn't object is by the time we go through this instruction conference, by the time it ultimately then gets to the jury, the parties overlooked it. So you're not going to object if you're overlooking the error.
About that. So let's set aside Whitlow and the footnote for 1 minute. Would you agree at least that under the rules, 1.924, an objection was required to preserve error with respect to the verdict form?
924 imposes an obligation on the trial court and all parties to get the instructions correct. I mean, that's true. 1.924 does impose an obligation that parties object. But what happened is this is a very unique, discrete, finite situation that usually doesn't happen. And that's why the Supreme Court, when it authored Whitlow in a unanimous decision, held that the error was still preserved.
Our old case law, prior to the adoption of the rule, allowed for a party to raise a claim and challenge jury instructions where the error was overlooked, kind of an inadvertent error. And then there was a timing requirement. You could raise it within 5 days. We adopt the rules of civil procedure and explicitly state this is done with the intent to change the old rule. If you overlook the error, then that's too bad. You have to preserve it. So given that history, how do we square that with this case?
Very unique, exceptional circumstance where the court, in issuing the Whitlow decision.
Let me follow up on Whitlow a little bit with you now. I wrote a case earlier called Lohr, where we, I think, affirmed, I don't remember what we did, but it was a grant of a new trial. And what I said in that case is if the new trial is granted, the district court can overlook error preservation as to just about every ground except jury instructions, because there's a rule and there's precedent that said there you can't overlook error preservation. Now, we fast forward to Whitlow. It seems to me in Whitlow, there were multiple reasons the judge could have granted a new trial, because there was a defendant that just wasn't dealt with. It was a huge problem. The judge granted a new trial. The court could have said, could have cited another ground for doing it other than error in the verdict form. I mean, although that was the fundamental problem. And that is kind of a unique situation, isn't it? That isn't what we have here, right? You have a denial of a new trial, and you didn't raise the objection at the time.
Case, the verdict form had the effect of instructing the jury not to make a determination of negligence as to one of the parties. It's exactly what happened in this case. The jury was not given the opportunity to make a determination of negligence as to BNSF.
1.924, you've been raising that quite a bit. It says, but if the court thereafter revises or adds to the instructions. So I don't care if Judge Gronwald did it on purpose or as a mistake or an oversight, regardless, what she did added to or revised. Okay, if that happens, similar specific objections or revisions or additions may be made in the motion. You don't have to. And if not so made, shall be deemed waived. How do we get around that?
Precisely the same thing that happened in the Whitlow case.
Since Justice Mansfield talked about, there are different circumstances and perhaps maybe more egregious, and maybe it really was a creature of, please don't ever have that happen again. Help me understand how that's any different than this rule. And what if Whitlow was wrong and we need to overrule it? Assume it was wrong. What's your argument? Don't rely just on Whitlow.
The purpose, and I can't speak for Justice Waterman who authored the opinion, or for the members of this court that participated. But if you think about the jurisprudence of Whitlow, it's to help preserve justice. I mean, here BNSF did not have its day in court because the jury...
A little bit about what not having your day in court. The defendants proposed a verdict form that just said, jury, do you side for plaintiff or defendant? And I don't think that that's an uncommon jury form that is used, or verdict form that is used. Would that have been error the way that you're talking about here if it just would have said, do you find for jury or for plaintiff or defendant to start out with?
Two responses. First of all, Your Honor, the defendant actually proposed the set of instructions that included the threshold question, was BNSF at fault? So we did propose the correct jury verdict form, which is a required element under the Whitlow case.
But the plaintiff, I think the plaintiff's verdict form just said, do you find for plaintiff or defendant?
General verdict form to find for plaintiff or defendant, and that would have been acceptable. The problem here is
acceptable. Then I think it gets to the difference between this and Whitlow, where the jury was asked to decide as to each of the parties in this case, whereas in Whitlow they were stopped before they could even decide with respect to the second defendant.
But a jury can only make a determination on the questions that it's asked. And if it was a general verdict form, either for plaintiff or for defendant, then the instructions at the whole would correctly state the law.
Make when Judge Gronwald gives you the instructions with a boo-boo in them. So how do we get around that and the rules? I think you're not having a hard time persuading me that it should have been perhaps a different verdict. But the fact of the matter is, it didn't happen. She gave you a chance on the record, and by you, I mean globally, gave the defense a chance on the record. Okay, how's it look? Judges are human. We make mistakes too. The perfect opportunity. So how do we get around that? And just assume for argument's sake that Whitlow does not apply.
It's because, Your Honor, again, with promoting justice, and this is not a case of sandbagging. There's nothing in the record that somehow BNSF was sandbagging by allowing the jury to be instructed to presume that it was negligent. No defendant would do that. Why would we want a verdict against us? So when you have an error that occurs through no one's fault, I think is my impression of reading Whitlow is that's what the Whitlow court was trying to accomplish. This was an error that happened when nobody's at fault, trial court and the parties. And
different dimension. I mean, it isn't like what the trial court didn't think it was prejudicial, and I'm not sure it was. I mean, if I have a son in college. Did he oversleep and did he miss his class? I mean, you know, you could separate that, or you could ask the jury, did his oversleeping cause him to miss his class? Well, if they didn't think he overslept, they're going to say no. I mean, I just don't see combining the two is that big a deal.
Iowa jurisprudence provides that jury instructions are erroneous when they are misleading or confusing, which this court has held. The definition of that is when it is, quote, very possible, end quote, that the jury could have interpreted them incorrectly. Mr. Leach.
Another opportunity to correct the error would have been when the jury comes back with the verdict. Were the lawyers still in town? I mean, did you have a, why didn't that kind of fallback happen here? They look at the verdict form and say, whoops, this isn't the form everyone agreed to. We could send, before we excuse the jury, give them the correct form and send them back in. Why didn't that happen?
Not aware whether the attorneys were still in town because I was not trial counsel, so I wasn't present. But I can say that the same thing happened in the Whitlow case, which I think is why this court said in footnote number 5, hey, you know, litigants, court, make sure that the jury verdict form is correct. And I understand that, and I think that's sound advice. But what happens when it is overlooked, nobody catches it, and that brings us here today. That's why this is such a unique circumstance.
I wrote footnote 4 and 5, and I'm wondering if we need to narrow or rein in footnote 4. If this is a recurring problem, shouldn't the party that failed to object pay the price consistent with the rule of civil procedure?
The fact that they're footnotes we're talking about, 2 footnotes in a case. Normally, when we have something to brag about, we scream up in paragraphs. Footnotes. Should we fix them?
If you look at the Whitlow case, it's a very, when you talk about a change in jurisprudence, which I think is what plaintiffs tries to argue, I conducted some research to see if I could find any other case where a criminal defendant is set free or all of these bad things that Mr. Leach claims is going to happen. I couldn't find one case in the 4 years since Whitlow was decided that presented this issue. And that's why this is a very unique issue. I mean, ultimately, the purpose in what we do is to try to promote justice. And at the end of the day, that's what the court did in Whitlow, and the Court of Appeals in this case directly applied Whitlow. Again, the jury was precluded from making a determination whether or not BNSF was negligent. It's only going to answer the question that's asked, and it was never asked that question. And so, respectfully, so that all parties have their day in court, the Whitlow decision was correct, and the Court of Appeals application of the Whitlow case was correct.
Thank you. Mr. Leach.
I think that this oral argument demonstrates the problem with the interpretation of Whitlow that's being urged on this court. If you look at it, we were talking about, well, did the counsel really overlook it or not? Were they present at the time that the verdict form, that the jury was brought back in and the verdict form was? Sure.
Point that your opposing counsel made. So, because I had focused on that page in the transcript where the defendant's counsel was talking about this combination of fault, but I was under the assumption that it was the final verdict form that they were looking at. And so if that verdict form had that first sentence, the first question, was there negligence, and then had the second question about did that negligence cause, or did the fault cause, that does change kind of that context of at least that discussion. And so back to the question that I think Justice McDonald asked you about when that final verdict form that's now been changed was given to the parties, the page that you reference in the transcript talks about that the instructions were given. Is there anything in the record that identifies when the attorneys would have first seen the revised verdict form?
The court, as the trial judges are aware, when they give us the jury instructions, they give us the verdict form also. That's not withheld from us. We had the verdict form. And the portion of the transcript that the court just pointed me to, that's where we created the verdict form that was given. that we actually created it exactly like it ended up. And that is exactly what we were discussing. And lest there be any doubt about that whatsoever, we know that in closing argument, when we had the verdict form, the court gave us, because you see us arguing from the verdict form, we even showed the jury how to fill out the verdict form. Defense counsel had the verdict form in closing argument, and at page 34 of what I believe is volume 7 of the transcript, this is trial counsel. But when you look at these things and you look at negligence, and Mr. Schmitt, my co-counsel who did the first part of closing, showed you what the definition of negligence is and what the definition of cause is, in whole or in part cause the accident, fault, when you look at fault, incorporates both of these. So when you look at that verdict form, was Mr. Rutledge a cause of this accident? He was not. Because we had created this verdict form as we did in closing argument, defense counsel used it as he helped us create it. And he said, okay, here's the verdict form. Let me walk you through it and let me show you how it is that you can rule in our favor, because you have to separate negligence, fault from cause. That was perfectly clear. And that's another reason why the trial court is so clear in her ruling on the motion for new trial, where she says, you know, I wondered, why didn't the court just apply Rule 1.924? Note that she applied Whitlow, but she never found that it was overlooked. She didn't say that. She jumped right over that. I think she kind of wanted to defend her jury instructions, but I shouldn't comment on that. But she did say this, from which that can be inferred. And this is at page 6 of her opinion, Appendix 1284. It cannot reasonably be said that because a space was not provided for the jury to write yes, indicating in writing that the jurors found BNSF was at fault, the jury therefore was not given the opportunity to first make such a finding and/or did not properly make that finding. As discussed, the information BNSF argues is missing from the verdict form is clearly and adequately included in other instructions, particularly Instruction 9, as well as supplemented by Instructions 8, 10, 11, 15, and 18. And I would add Instruction 1, and I believe it's Instruction maybe 27, in which the court tells the jury, listen, I did my best here. But no one instruction can contain all the law that's applicable. And so then later it says, so if you have any questions about this, ask them. But then it says, but you probably don't really need to ask us any questions. Just reread the instructions. That'll probably get you there. In other words, the whole point of the applicable standard of review, as in Lohr, and the court may recall that in the Court of Appeals opinion, Lohr is cited in the same paragraph as Rivera. Rivera was a case very similar to this case that had to do with the definition of, I think, business enterprise or something like that. And one of the sentences defined it pretty well. Then the next sentence kind of seemed to screw up that definition. So the defendant said, oh, now it's misleading. So what Rivera said was, okay, you can have a misleading instruction in there. Well, not you can, it's not okay to do that. But if you do, let's see if it's misleading. And that standard is the one that was reported to you. The standard is, could it very possibly have misled the jury? That is the standard. But that's the standard that then gets you to the rest of the standard. And the rest of the standard is, we must look at the instructions as a whole. Did the instructions as a whole mislead the jury? And the part of the transcript we're talking about, where the lawyers and the court talk about combining and uncombining, that's where we said, Judge, you're combining fault and negligence together for FELA apportionment. So make sure you separate it out in the verdict form, which in the issues which was done. I simply thank you for your time and your attention and for taking this case. Thank you.
Olsen versus BNSF Railway is hereby submitted. We'll have a brief pause here while we prepare for the next case, State versus Flores.